Hey folks, it's good to finally meet you. I suppose you're wondering why I'm missing the other half of my body. Well, to be honest, it would have costed extra for me to include the other half of my body, so I decided to go without it. I wanted to assure you that missing the other half of my body will not impact my lecture whatsoever. In fact, I'm sure you will enjoy the content as much as I have enjoyed it. Today we're going to be covering topics that affect you and me. Not to mention pretty much everyone around the world. Alright, now that we're back again, and away from deadly space radiation without a protective suit, let's go ahead and get started with today's lecture. I wanted to talk to you all about two major important events in the civil rights movement. The Brown versus Board of Education, and the Little Rock Nine. The Brown versus Board of Education was perhaps the cornerstone of the civil rights movement in the 1950s because of its sheer impact on education as we know it today. The reason Brown versus Board of Education ruling was so important was because about 60 years earlier, the Supreme Court had ruled in Plessy versus Ferguson that racially segregated public facilities were completely legal, so far as the facilities for blacks and whites were equal. The Plessy versus Ferguson ruling created sanctions and laws barring African Americans from sharing the same buses, school systems, and other public facilities as whites. These were also known as the Jim Crow laws that established the separate but equal doctrine that existed until the 1950s. So you might be thinking to yourself, what exactly is it about this Brown versus Board of Education ruling that changed the future of education as we know it? Alright, well, let me explain. In the groundbreaking piece of legislation that would shape the future of education as we know it, a man by the name of Oliver Brown ended up filing a class action lawsuit against the Board of Education in Kansas. This guy right here, he's Oliver Brown, and he's the one who filed the class action lawsuit. This young lady right here, that's Linda Brown. She's the daughter of Oliver Brown, the daughter of the man who filed that lawsuit. Now imagine, if you will, that you're Oliver Brown, and the Kansas Board of Education has just informed you that your daughter is not allowed to attend a school based upon the color of her skin. I'd like to think I'd be pretty upset about that as well. Now, Oliver Brown claimed that the segregation disregarded the so-called Equal Protection Clause of the 14th Amendment, which clarifies that no state can deny any person within its jurisdiction the equal protection of the laws. Now, finally, the case went before the U.S. District Court in Kansas, which agreed that public schools segregation had a detrimental effect upon the colored children and contributed to a, quote, sense of inferiority, although they still upheld the separate but equal doctrine. Now, this guy right here, Thurgood Marshall, was the chief attorney for the plaintiffs. And coincidentally, just 13 years later, President Lyndon B. Johnson would appoint him as the first black Supreme Court justice. Now, this guy right here, the infamous Chief Justice Fred Vinson, not to be confused with the warden from Shawshank Redemptions, held the opinion that Plessy versus Ferguson verdict should stand. Now, as fate would have it, Chief Justice Fred Vinson, just kidding, that's the warden from Shawshank Redemptions again, that's better. Chief Justice Fred Vinson passed away just moments before the final verdict of the Brown versus Board of Education. Dwight D. Eisenhower eventually replaced Chief Justice Vinson with Earl Warren, then Governor of California, who displayed considerable judicial acumen in his verdict against school segregation the following year. In the landmark decision issued on May 17th of 1954, Earl Warren wrote that in the field of public education, the doctrine of separate but equal has no place, as segregated schools are inherently unequal.
This is a conspiracy. That's what this is.
Much to the chagrin of Chief Justice Fred Vinson, the courts finally ruled that the plaintiffs were being deprived of the equal protection of the laws guaranteed by the 14th Amendment. Alright, now that we've covered some of the tenets of the Brown versus Board of Education verdict, you might be wondering to yourself, how does this connect to the Little Rock Nine event? Well, let me explain. In May of 1955, the Supreme Court issued a second opinion in the case of Brown v. Board of Education Part 2, which indicated that future desegregation cases to be held in lower federal courts and directed district courts and school boards to proceed with desegregation. Now, as they say, the road to hell is paved with good intentions. That Supreme Court ruling, though well-intentioned, led to a whole bunch of nefarious actors evading desegregation in the South. Although Kansas and some other states abided by the verdict, a lot of schools and local officials in the South defied it. In one primary example, Governor Orville Faubus of Arkansas called out the state National Guard just to prevent black students from attending high school in Little Rock. In a very intense standoff, President Dwight D. Eisenhower eventually deployed federal troops, and those 9 famous students, known as the Little Rock Nine, were finally able to enter Central High School.
Okay, that's it. I hope you've enjoyed that video as much as I enjoyed making it. Now, you might be asking yourself, why would I make a video about the Brown versus Board of Education and the Little Rock Nine, and what on earth does that have to do with ethics and multiculturalism? Well, that is a very good question, and that is something that I would like you to answer in the discussion board post. And with that, I will see you during our next meeting, and I hope you have a very good week. See you guys.